Harper Review recommend change to Australia's cabotage regime and liner shipping exemption. On 31 March 2015, the much anticipated final report of Australia's Competition Policy Review Panel was released. The panel has recommended the abolition of the liner shipping exemption to Australia's anti-cartel laws and the deregulation of the current cabotage regime, two recommendations that will be of considerable interest to the maritime sector and the many sectors which rely upon it, both within Australia and throughout the Asia-Pacific region. In 2013, the incumbent Liberal National Party coalition government of Tony Abbott government commissioned an independent root and branch review of Australia's competition laws and policy in recognition of the fact that the Australian economy has changed markedly since the last major review of competition policy in 1993. The review was undertaken by a four-member competition policy review panel chaired by Professor Ian Harper, Harper Review. The recommendation regarding the liner shipping exemption and cabotage comprised just two of total of 56 recommendations. Australian competition law and the liner shipping exemption. Part X of Australia's Competition and Consumer Act 2010 (CCA) permits liner shipping operators to enter into agreement among themselves in relation to the freight rates to be charged and the quantity and types of cargo to be carried on particular trade routes and register those agreements. Registration confers an exemption from the cartel conduct prohibition in the CCA that would otherwise be applicable. For almost 50 years, Part X has provided liner shipping services with a degree of immunity from Australia's competition laws. The exemption for registered agreements between shipping operators, which may otherwise amount to illegal cartel behavior, such as price fixing, was enacted and has survived due to concern regarding cost, capacity, and scheduling. Consortia arrangement between shipping line enable the sharing of space on pooled vessels so that a more frequent and wider range of port calls can be offered to shipper at a much lower cost than would otherwise be possible. It is therefore unsurprising that Part A has enjoyed and continues to enjoy strong support from shippers in Australia. Many of Australia's major trading partners, including China, Japan, Korea, Singapore, and the United States, have competition laws permitting similar consortia arrangement between shipping lines. The most recent major review of Part X were conducted by the Australian Productivity Commission in 1999 and 2005. In 1999, the Commission concluded that on balance Part X served Australia's national interests, whereas in 2005, the Commission recommended the Part X be repealed or reformed. In response to the 2005 review, the then Australian government opted for reform rather than repeal. The Harper Review's recommendation regarding the liner shipping exemption. With respect to Part X, the Harper Review has recommended that it should be repealed and the liner shipping industry should be subject to the normal operation of the CCA. The Australian Competition and Consumer Commission (ACCC) should be given power to grant block exemption for conference agreements which contain a minimum standard of pro-competitive features. The minimum standard of pro-competitive features to qualify for the block exemption should be determined by the ACCC in consultation with cargo interests and the liner shipping industry. Other agreements that risk contravening the competition provision of the CCA should be subject to individual authorization, presumably on the basis of the normal net public benefit test. A transitional period of 2 years is allowed for the necessary authorization to be sought and to identify agreements that qualify for the proposed block exemption. The panel made this recommendation despite having had the benefit of detailed and persuasive submission from the big industries bodies in Australia representing carriers and shippers arguing for the retention of Part X. The repercussion of a repeal of Part X. Any repeal of Part X would represent a number of challenges for stakeholders and not least of all exporters, importers and consumers within and outside Australia. It would seriously destabilize current linear services which are vital to the continuity of access to all export markets. It could deprive shippers and by extension their customers of the reduced cost, more frequent sailing and increased choice that Part X facilitates. It would replace the certainty of the Part X arrangement with complexity and bureaucracy at a time when the maritime sector is already being subjected to unprecedented levels of regulation. It would result in Australia adopting a law inconsistent with the laws of many of its major trading nations, adversely impacting open international liner shipping arrangements throughout the Asia-Pacific region. In the longer term, it could facilitate regional market domination by the major line on our super alien. Should the Abbott government or any subsequent Australian government contemplate acting on the Harper Review's recommendations regarding Part X, they can expect robust submission from the same key stakeholder whose comprehensive and persuasive submission appear to have been largely ignored by the Harper Review. Cabotage following the enactment of the Coastal Trading Act. On 1 July 2012, the previous Australian Labor Party ALP government of Julia Gillard enacted the Coastal Trading Revitalising Australian Shipping Act (CTA) and related legislation, the most comprehensive change to the regulation of coastal trading in Australia in almost a century. The CTA replaced the relatively simple system of license and permit existing under the Navigation Act 1912 with a complex three-tier licensing regime comprising general license, temporary license and emergency license. For more information, since the enactment of the CTA, operators of foreign flagged ships wishing to participate in coastal trading have been forced to deal with a set of procedures that are cumbersome, bureaucratic, impractical, uncertain, and heavily staggered in favor of Australian operators.